right, my friends. I just pressed the Let's Go Live button, so let's wait for those tubes to fire up all across the fruited plains of the interwebs. It looks like they've connected themselves. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we've got three great segments coming up for you. Can't wait to get into them. We're talking about Judge Juan Merchan out in New York, and he's got a big Kamala problem because, of course, the daughter of the judge works for Kamala. And so Trump's defense came out. They filed a renewed motion to recuse Judge Merchan to get him out of there. This is the Alvin Bragg case. And we'll talk more about the daughter because we actually have her website pulled up today. And it's still bright and prominent on there that she is now working, the judge's daughter, for Kamala for Harris on her own website. So it seems like it's a little bit of a conflict if the judge is going to sentence Trump when the judge's daughter is literally working for Kamala for president. Not good. So Trump's team submitted one of those pre-motion letters, very small, but we'll read through it. And also the Court of Appeals there in New York has said that the gag not going anywhere. All right, Trump, you're going to continue to be gagged, even though the case is over. There's no witnesses who are testifying. There's no jurors that we have to be concerned about. So all of that is no longer important. So we'll talk about that. Then we're looking at the immunity issue because Trump is now demanding, we've already covered several of these filings, a dismissal. Trump, of course, as we know, has 36 guilty verdicts that have come down, 34, my mistake. And Trump says all of them need to go bye-bye. And so we have the final reply from Trump's team. They submitted a motion to dismiss after the Supreme Court came down with their immunity decision. We had Alvin Bragg respond, and then Trump's team has issued their final reply. And so we'll read through that. It's 20 pages of deliciousness. And then we've got some updates on the J13 business. Local cops in Butler also now speaking out. They're tired of being a punching bag for the Secret Service. They're saying that the Secret Service story is very misleading. As we know, they are saying misleading. We'll call them liars, but all right. So we'll talk about all that. And we got a couple new interesting videos that just dropped. One just came out today from a gentleman on X. And he was saying, right, when they brought Trump out on the stage, he has this video that we'll share where he has got the snipers up there on the roof. And they're already looking over there in that direction where Crooks is. What the heck's going on over there, man? What's going on? So why'd they bring Trump out if the snipers were concerned? And those were Secret Service snipers. So we're going to go into all of that. And I'm very grateful that you are here and with us because we got some good segments. We got some court documents to get to. You know how much we love some good court documents. Now, before we get into any of that, my friends, you know what we got to talk about here today, don't you? That's right. Bird flu. And this one is talking about our friends in Texas, man. It's not good. This came over from the University of Minnesota, CIDRAP. Says there's a previously undetected H5N1 avian flu case in farm workers, apparently discovered in a new report. They're calling it highly pathogenic. Highly pathogenic. Whew. Good thing I didn't go to medical school. H5N1 infections in 2 Texas farm workers, man. No, not Texas. Not previously confirmed to have the disease. The investigators also cultured infectious virus from the milk and cattle samples. Oh, man. 2 of the 14 workers test positive, and, you know, this is a thing. And so the question is, what can we do about it? One thing we can do is be prepared. How can we do that? Well, our friends at The Wellness Company. And we've got a link down to them in the description below. But they've got some good stuff over there, including a contagion prescription emergency kit. I've got mine right here, and it's filled with a bunch of good stuff in it. The only kit of its kind, you're going to find inside stuff that's for bird flu, for COVID, for respiratory illnesses. You never know what's going to pop up. Inside ivermectin, hydroxychloroquine, Z-Pak, Tamiflu, baby, budesonide, nebulizers, everything that you're going to need so you can rest easy, knowing you've got it on hand in case you need it. And there's a guidebook inside that'll show you how to use it. So this is backed by research from people like Dr. Peter McCullough. The Wellness Company's Contagion Emergency Kit is prescription, and it's a kit that every American should have in their home. Getting yours is easy. Go to twc.health/Robert. Links are down in the description below. And when you use code Robert, Robert is the code, you'll save and you'll get free shipping. It's even easier than going to the doctors, so you can be prepared. Check it out, twc.health/Robert, code Robert at checkout, and these kits are only available in the United States. All right, and so thanks for supporting our sponsors, my friends, and for getting prepared out there, because it's important to do. All right, so let's get into it. Judge Merchan facing a Kamala problem. We know that the judge's daughter had a very interesting connection with Joe Biden, but Joe Biden's not running for office anymore because he ran away like a coward after they threw him out. But now it's Kamala who's in charge. And so does Judge Merchan in New York, the one where Alvin Bragg prosecuted Trump on 34 rigged felony charges, does she, the judge's daughter, have a connection with Kamala? Well, turns out, yeah, she does. In fact, this is the judge's daughter's website. You can see this is Authentic Campaigns. She has a list here of who they are. This is about Authentic. We're an award-winning digital marketing agency that works for Democrats, and they do. And here's our work. If you click this tab, you'll scroll down, you'll say it's a bunch of lefties, including Katie Hobbs from Arizona. Ugh. We also have more. Keep on scrolling. Look at this one, Joe Biden. They work for Joe Biden. This is Lauren Mercan's company, right? She's a high portfolio, a high qualified credentialed person here who works on all of these, building out their portfolio. And Joe Biden's on the list. And so when you scroll down, you're going to see just a bunch of other organizations. But the big one, the concerning one, okay, Joe Biden's not around anymore. They already said Joe Biden is a problem. Judge said it's not close enough, and so we're not going to recuse ourselves. But now watch this. We keep scrolling and scrolling and scrolling, and featured clients are Biden-Harris. And below that, dun, 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 Kamala Harris for president. See that right there? Yes, we do. Oh, yes, we do. It's right there. Kamala Harris for president. So, if the judge's daughter is working for Kamala Harris for president, does that mean that the judge might be a little bit biased, lacking impartiality? Yeah, theoretically, because their interests are aligned. She wants to help Trump win. I'm sorry, help Kamala beat Trump, and Daddy can put Trump in prison. So they are working together to achieve their political ends. This is from their website. It's public right now. Everybody can see it. And so Trump's defense has now come out and said, all right, Judge Merchan, we've got enough of this, all right? Says, listen, Honorable Juan Merchan, acting justice, and that's an understatement, saying, you're on the Supreme Court for the criminal term. This is the case of People versus Trump. And as a reminder, this is a little permission slip form that we have to submit because this judge is such a Merchan that he has said, don't you file big filings publicly, okay? Just write this little permission slip and then I'll let you know if I want to hear more from you. And so Trump's people, it's so ridiculous we even have to go through it this way, but they have the ultra narrow margins, as you can see. You're like, what the heck's going off this filing? Why is it like coming off the page? Because the judge says you only get one page. So they're squeezing every freaking character that they can on here. They could have maybe put one more, just a couple words there, pick your three, whatever, put them in there. That's it. So it's pretty damn good. And the printer probably broke. They probably broke like 3 printers, margins, errors. We can't do it, Captain. You know the routine. But here is what they say. All right, Judge Merchan. In light of the long-standing and extremely beneficial working relationship between Your Honor's daughter, Lauren, and Kamala, who recently became the presumptive presidential nominee of the Democrats because of this little love fest between them, we respectfully submit this pre-motion letter to renew our request that the court recuse itself. This letter can be deemed the motion, and we request permission to file a reply within 1 week of Bragg's opposition, which we expect to happen any minute now. Alvin Bragg will come back. No, Your Honor, you're totally unbiased. Kamala is no different than Joe. You were already saying that you're disconnected because your daughter's not a close enough relationship. There's not enough proximity there to cause a conflict of interest. And so we just sub out Joe with Kamala. Okay. So the recusal application, continues Trump's defense, is based on the state and federal constitutions. You need to go. And Judiciary Law, Section 14, and New York Code, Section 100.2 and .3. And we incorporate by reference the other legal authorities and evidence submitted with President Trump's prior recusal motion, which you ignored and denied. Saying, all right, Judge, President Trump is the Republican nominee for the presidency and the leading candidate in the 2024 presidential election. Now, Kamala Harris emerged as his presumptive opponent after it became apparent to the public that the Biden administration's lawfare against President Trump was motivated by President Biden's alarming decline, evaporating in front of our eyes. So then Harris immediately framed her candidacy with a specific false reference to this case. She called it, she's talking about it in her campaigning right now, a prosecutor versus a convicted felon. So Harris is now bringing in this rigged prosecution in her little campaign. Your Honor, Mercan has insisted on maintaining an unconstitutional gag order that we're going to come back to because the Court of Appeals has ruled on that, backed by threats of imprisonment made during this trial. If Trump even says a thing, you're going to lock him up. He can't even talk about the judge's daughter or the judge. He can talk about the judge, but not those specific things, or, the conflict that the judge has as a result of his daughter working for Kamala, previously Joe. So Trump is prevented from fully responding to that inaccurate attack. They can say what they want about him, but he can't respond. Now, making matters worse, Your Honor, this week, the Biden administration unveiled an unprecedented plot to mount a political assault on the Supreme Court because they granted presidential immunity. And that immunity is central to Trump's pending motion in this case. Now, the gag order even prevents Trump from engaging in constitutionally protected speech, and it prevents us, by the way, from hearing it too, by drawing attention to the obvious connection between Biden and the prosecution. No candidate, which is, as we know, through Matthew Colangelo, the prosecutor who was the third in charge, third in line at Biden's DOJ, before he decided, I like New York. I'm going to go hang out with Alvin. No candidate for office, much less a presidential candidate, has ever faced such an insidious prior restraint. No, that is absolutely true. Nothing like this ever. It's 234 years of historical precedent. Democrats right in the shredder with the Constitution. As there is no threat to the integrity, Your Honor, of the remaining proceedings from Trump's protected political advocacy, the bias reflected in this court's handling of this issue is manifest. There is no reason to continue to have him gagged. Trial is over. All of the pre-delineated justifications for why he can't speak political speech and why we can't hear that political speech no longer apply. Trial's over. Not concerned about witnesses. Not concerned about jurors. Not concerned with the lawful administration of there's a sentencing hearing. That's it. That's left. If that even happens. So get rid of the gag. Oh, or was it about the administration of justice or not? Was it actually about protecting witnesses? No. Was it about protecting jurors? No, because they were never in any jeopardy at all. It was all just a pretext to shut Trump up from being able to campaign and call out the corruption that is happening in this courtroom. And that is why we have the First Amendment. That's why it's number one. It doesn't come second, third, fifth, seventh after administration of justice. Then you can have free speech. You have to be able to speak about the corruption, and they are gagging him from doing that. So Your Honor's daughter, they get into it, has a long-standing relationship with Harris. Including work for political campaigns. Oh, okay, good. She has obtained and stands to obtain in the future extensive financial, professional, and personal benefits from her relationship with Harris. Now, Your Honor's daughter was publicly critical of President Trump's use of Twitter. We played that clip. She was on a podcast. saying, daughter was on a podcast saying, my dad doesn't like when the president uses Twitter. Says it's unbecoming of a politician. Now, this was a central issue in the pending presidential immunity motion, and it was described a discussion on that topic with Your Honor that evidences prejudgment of President Trump's official acts argument. So the judge has already come to his conclusion. Now, in 2020, Judge, Your Honor's daughter, Lauren, was openly hostile to President Trump on social media. She was posting all over the place. Your Honor's daughter, Lauren, is also a part owner and an executive at Authentic Campaigns, which was the top vendor for Harris's prior presidential campaign based on disbursements of nearly $5 million. It also touted its subsequent work for the Biden-Harris campaign in connection with at least the 2020 election, probably ongoing, right? So we don't know how far back those little monikers on the website go. They're still up there, though. And Harris is running for president again. So did she just continue on? She's like, well, we already had an account with you, so just carry it on. We'll just, you already had some funds left over from that other thing, so just, parlay it over. And made tens of millions of dollars by helping other politicians disseminate political advertisements based on this case. Now, on October 20th, 2023, during this case, Authentic posted an image of Harris to its Instagram account with the caption saying, happy birthday to the MVPs of MVPs. Oh, isn't that nice? At Kamala Harris, saying, here's a little throwback to when she stopped by our DC office to celebrate the launch of her presidential campaign in 2019. Oh, how far we've come. So they love each other. Now, according to the FEC filings, Authentic has received over $12 million in disbursements from Democrat and progressive politicians and PACs since January 2024. Now, although Authentic restricted its Twitter account following scrutiny of this recusal issue, the company's public Twitter profile currently features Harris. Amazing. Now, according to the public reports around July 29th of this year, Authentic's founder, a partner and colleague of Your Honor's daughter, leads a group called White Dudes for Harris. Oh, that racist clan. Kamala's communist clan. Joining up on their Zoom calls, raising millions of dollars, BFFs with the judge's daughter. It's perfect. Was the judge on the call? Or he's from what, like Colombia or something? Is he allowed on that call? I don't think so. Sorry, Judge. Even the judge is not allowed on their clan call, their Kamala clan call. So, which has raised millions of dollars for Harris's current campaign against President Trump. Now, the court's unjust and unconstitutional gag order continues to restrict President Trump's ability to respond to Harris and to address these topics with the American people. And so regardless of intent, Your Honor, decisions by you in this court on the pending presidential immunity motion and that any sentencing would benefit not only Harris, but also the professional aspirations and the financial status of your daughter and Authentic. And by the way, remember, Authentic was also running ads talking about this case. They were doing it for Pencil Neck Schiff, but they were running ads saying, good news, Trump was arraigned in court. All in a manner consistent with the prohibited political contributions by Your Honor that led to a caution from the Commission on Judicial Conduct. Now, given the proximity to the last election, Judge, and the pernicious effect of the gag order, President Trump's concerns are not, quote, hypothetical at all, as you last asserted last August. Now, President Trump's second recusal motion was also accompanied by evidence attached to a sworn affirmation, and not, as Your Honor indicated, it wasn't innuendos, it wasn't unsupported speculation. We had a written document, an affirmation that was submitted. So recent developments, Judge, are even more concrete than the last time. And the court has not addressed any of these issues at a level of detail sufficient to repair the lack of public confidence in the integrity of these proceedings. And so accordingly, President Trump respectfully requests that the court address the actual conflict and the appearances of impropriety by recusing yourself prior to the resolution of the pending presidential immunity motion. So remember, Trump and the defense and the judge and the government are always waiting for a decision on September 6th. They're coming back later in September for a sentencing proceeding, but they're saying, Judge, you have to go now. We're not going to wait for you to decide this immunity motion. You're biased as hell. Your daughter is making moolah of Kamala. Kamala is what she's making. So Todd Blanche and Emil Bove send that over, and it's just nicely done. So they get one page. They crammed every freaking word they could squeeze in there, man. It's sorry to use that F-bomb there, but it's true. It's like impressive. It's like, wow. I mean, they probably even had to shrink that logo up and everything. Todd Blanche is like, he's like an American hero. He's like, jeez, my email's like it's like 8-point font already. Shout out to Todd Blanche, man. Really squeezing it in there. So we have that. Now, the Court of Appeals there in New York continues on with the gag because they're pieces of work like the rest of the judicial body in New York. We see here, Blanche Law signs this one for the petitioner, and this is the order from the Supreme Court. So these are the parties on it, Bragg, Blanche, and the rest of them. Here we have the official Court of Appeals for New York saying that here petitioner says that there's a cause of action here. Trump has been prohibited from communicating pursuant to the gag order. So Trump has challenged this. Following the verdict, so the case is over, or not yet, we have sentencing. Judge Merchan granted some of the motion, terminated some of the provisions that allowed him to talk about witnesses and the jury. But the judge maintained that the court and the district attorney staff were thereby continued to be covered in the aftermath. And so you can't talk about the judge's daughter who works for Kamala, saying that Trump's contention is at the conclusion of the trial is now a change in circumstance. Okay, it's over. And so we should be able to talk about this. The courts, they say, are allowed to do this, right? Now, courts are empowered to protect against the unfair administration of justice. And the fair administration of justice includes sentencing, they say. So just because the verdict has happened doesn't mean that it's a free-for-all, they're saying. Indeed, under the CPL, a criminal action terminates when we have a sentence or other final disposition in a criminal court. And this is an interesting one, right? For all the people who are running around screaming, oh, Trump's already been convicted and all of that. Like, case is over. It's convicted. Now, it's the law says right here, cited by them, CPL 1.216C. Under CPL, a criminal action terminates with the imposition of a sentence or some other final disposition. It's not a final disposition. They're even saying it, right? Gag order's in effect because it's not final. So he's a convicted felon? I mean, like, not really, like, kind of like one half of a convicted felon. Like, that's it. He needs a sentence until it's like official. It's still open. So, yeah, so that's, right, even the Court of Appeals is citing it. So they can enjoy that one. Now, accordingly, since the underlying criminal action remains pending, it's not over. So, okay, Justice Merchan did not act in excess of jurisdiction by maintaining the narrowly tailored protections in paragraph B. So you can't talk about my daughter. Contrary to Trump's contentions, government Bragg's evidentiary submissions demonstrate that Alvin Bragg got some nasty threats. He's so pressed, of course, after the jury verdict, and to continue to pose a significant and imminent threat. And so we've considered Trump's requests, find them unavailing. Gag order remains in place. Still can't talk about the judge's daughter, even though she works for Kamala and Joe Biden. Saying the unfair administration of justice, the courts can protect against that. So Trump can't talk about all of the corruption that's happening in the New York system from top to bottom. Everywhere we go. Judge Kaplan at the federal level. We had Cy Vance leave, brought in Alvin Bragg. He brings in Colangelo. They rig these cases. You have Tish James rigging it at the AG's office. The whole system there is just insane. Even the appellate courts are like, well, yeah, nobody needs to hear from Trump. The First Amendment is supposed to protect against this, to stop them from covering up their corruption, but they'll continue to gag him. So Trump has submitted his reply, talking to the judge, telling the judge to recuse himself. We're looking forward to the judge not recusing himself, but continuing to figure out how to resolve this because he's in a precarious position now. The immunity decision from the Supreme Court said that Trump was in fact immune, or at least had a presumption of immunity, and a bunch of the evidence that was submitted in this case was official acts. They actually brought witnesses in to testify about the work at the White House. So Merchan goofed big time, and now they're going to try to just squeeze what they can out of this, gag orders and extensions of hearings so that the political pain and pressure can continue to come from them. But we'll be here continuing to cover it, my friends. And so thank you for subscribing wherever it is you're watching this. We'll look forward to seeing you back here on the next one. Now, we're not done yet because we're carrying on. We're sticking in New York and moving forward with Alvin Bragg and immunity. President Trump submitted his final reply on the presidential immunity issue. Here's what it looks like. We know this is the case involving Alvin Bragg's prosecution, 34 felony guilty verdicts from New York. Judge Juan Merchan presiding over this thing, even though his daughter works for Kamala Harris now. But here is Trump's final reply. And so remember, the way this goes is Trump submitted a motion saying that the verdicts need to go bye-bye. They need to be dismissed because presidential immunity applies. And they lodged their objections many times before the trial even started. And then when the trial started, they lodged it again. They said, Judge, you have to stop this now so that we can determine whether there is immunity. There's a pending case at the Supreme Court. Just pause this so that they can sort it out. Then we'll come back and deal with it. The judge said, no, I'm not going to do that at all. We'll just have a trial because they needed the conviction for the election. Well, the judge screwed that up. The court came back down, said immunity does apply. So Trump said, time to dismiss the case. Bragg responded. Now Trump is submitting a reply, and we'll see where this goes. But let's unpack what's inside. The table of contents is here. We're looking forward to reading these 20 pages of beauty, and they start with the following. All right, Judge Juan Merchan. The Supreme Court of the United States ruled conclusively and unequivocally that President Trump is protected by immunity for his official acts, period. Now, in this case, a politically motivated Bragg violated that immunity. And he did it by using official acts evidence in grand jury proceedings before this even ever started and at trial, which we covered here extensively. And so therefore, because he did that, this case must be dismissed and the jury's verdicts must be vacated. Now listen here, Judge. President Trump respectfully submits this reply in further support of his motion on immunity and in response to Bragg. Now, Bragg, when he submitted his response, Bragg concedes that the Trump Supreme Court decision from the Supreme Court was an intervening decision. So it came back down and intervened in the middle of a case. Like, this case is not over because sentencing hasn't happened. And so it's coming back, like it's still ongoing, it's still pending. It's not like, hey, game's over, you can't change the score, sorry. And that resulted in a newly announced rule. Okay, so Bragg is like, oh crap, like, all right, yeah, like, okay, this came back down. Now, Trump's team says, because that is true, and because President Trump raised presidential immunity objections with this court and the Court of Appeals before this even started, Bragg's preservation arguments are meritless. And in Bragg's reply, he said Trump didn't object. And you have to object in order to preserve that issue on appeal. You can't just say, well, I want to appeal. Well, why? Well, because you did a bunch of stuff wrong. Well, what do you think we did wrong? Well, I saw you did that. Well, did you raise it when we did it? No. Okay, well, you can't bring it up now. You forfeit that right. You waived it. Bragg said they didn't even talk about immunity, which was insane. Right? I think in a real court, he would even be like, come on, like a judge would scold him for that. Dude, they raised it clearly many times. We saw it in the X scripts. Immunity multiple times. Judge says, shut up. Stop raising those objections all the time. You don't need to raise it after every question, is what he said. So it's ridiculous. Now, Bragg fought President Trump's pretrial motions, which were they're in writing. So we submitted it in writing, immunity. And Bragg urged the court to rush ahead to trial anyways. And you did that, Judge. And that was wrong. The Supreme Court in the Trump case made clear that pretrial review before the trial starts was necessary. You have to have some sort of an evidentiary hearing to decide, is this immune? Is there a presumption of immunity, or is this unofficial and there is no immunity? Where does it fall? Now, President Trump is entitled to absolute immunity and to disputes that a rebuttable presumption of presidential immunity can ever be sufficient to protect the interests at stake, which is an issue the Supreme Court expressly left open. So let's read that one more time, because they're disputing the second half. It says, Trump is entitled to absolute immunity, and disputes that rebuttable presumptive presidential immunity can ever be sufficient to protect the interest at stake, which is an issue that the Supreme Court left open. But in light of this resistance to the reasonable pretrial request to wait for the Trump decision, Bragg is not entitled to a post-trial rebuttable opportunity. The bell cannot be unrung now, so we can't fix this after the fact. Bragg's presidential immunity violations were not merely trial errors. The violations were not harmless like they're claiming. Their star witness committed perjury before and during the trial. And so in any event, harmless error review is an inadequate safeguard for these structural violations of the Constitution, which adversely impacted the mode of the proceedings mandated by the Trump court on the immunity decision, and the constitutional structure that will guide the future president. And so the Supreme Court came down and they gave us a framework. We said that our propositions to the court were to wait till they gave us a framework so that we could come back, apply that framework, say, okay, they want us to go this way, so we do that. Then we can settle that. Then the trial can move forward if you found that there was, in fact, conduct here that could be charged. But you don't get to do that after the trial. It has to happen before, is what they're saying, before the trial occurred. And so that's the opening statement, but they get us some more details here. They tell us, there is no procedural bar to dismissal. Part of what Bragg was saying is that Trump was out of time. He raised his arguments too late. The verdict has already been rendered, right? Time's up. Clock has already expired to zero. They say President Trump's dismissal motion was not waived. We didn't forfeit it at all. In the Supreme Court case, the Supreme Court addressed first impression questions of lasting significance, and they issued a newly announced rule. Now, thus, Trump, the Supreme Court case, constitutes good cause for the timing of the motion. Okay, so in other words, Trump didn't delay this. Trump wasn't waiting around and maybe we should file it and not. As soon as the Supreme Court came down, boom, they turned around, filed. Oh, perfect, new rule. We can file that. And so remedying this is in the interest of justice. So it's a pervasive presidential immunity violation. We already objected. We already told you to wait. You said no. New rule came down. We say it applies. And it does. They say the split decision in the case that Bragg cited doesn't support their arguments. Why? Because that concerned another issue, which was a distinct issue, which is about appellate preservation and was not about good cause or interest of justice. Not like that at all. Here, President Trump has presented the argument to this court. There's a clear and adequate record already. And in that other case, it relied on other things that are not raised here. None of that applies here. So they say this is why dismissal is required. It's in the interest of justice. The essence of immunity is that a possessor's entitlement doesn't have to answer for his conduct in court. That means everything. It doesn't mean you're only immune from a conviction, like you can go to trial, you have to show up to court multiple times, you have to sit there where you have, Bragg or Tish James, harassing all your people. You just have immunity. You don't have to suffer all of that from the outset. Now, the Supreme Court rejected the claim that grand juries will not permit political or baseless prosecutions from advancing in the first place. This is a sentence the government always comes back and says, well, that's why we have checks and balances in the system. What checks and balances? Well, we have honest prosecutors. Yeah, right. Okay. What else do you have? No one believes that. What else? Well, we have unbiased judges. Okay, so what else do you got? Well, we have like the people, like grand juries who are like going to be a check and balance. Okay, right. So the same grand juries that we know will indict ham sandwiches and show me a person, I'll show you the crime thing. The same grand jury that will do whatever a government prosecutor and a judge tell them to do. Yeah. So no, they're not checks and balances. It's ridiculous. And the Supreme Court said that too. We're not just going to believe you. Presidential immunity is necessary where a prosecutor is trying to charge the president for his official actions. The Constitution says the president can do this, so you cannot be charged with a crime for that. Bragg violated the presidential immunity doctrine by presenting official acts that he's allowed specifically to do by the Constitution, evidence to the grand jury. Therefore, the indictment must be dismissed. Is Trump allowed to have a conversation with his White House comms director? Of course. Should that be protected as official acts when you're governing the White House? Of course. It's happening in the White House. It's about official stuff. They've said that presidents can't respond. Part of their job is to respond to other public issues, including attacks on their credibility. Right? It's part of the job. It's an official act. You have to communicate about these things. Getting attacked by the press is part of the job. So therefore, the indictment must be dismissed. Now, Bragg offers no independent arguments, of course not, about the official acts evidence that they presented to the grand jury through this person. He offers no independent arguments about any of this through this person and through this person. So these are probably like two official people, right? This is an official person here and an official person here. Can you get to any evidence that they brought in independently from someone else who's not official? No. And so for those reasons, that evidence violated the immunity doctrine. These are official people. Bragg's mischaracterizations of arguments about this person or thing as vague and cursory are not a basis for ignoring other additional violations of Trump's immunity. He has immunity from official acts, SCOTUS said that, including from testimony of one another from his closest White House advisors. And so Trump's motion cited to this and that challenged testimony, which included conversations that Blank had with President Trump during his first term in office regarding these issues. And similar to White House conversations with Hope Hicks, who was White House comms, President Trump's statements to Blank were part of discussions in which he was seeking advice from Blank, official, regarding Blank, presidential stuff. And so likely due to the fact that the president's need for complete candor and objectivity from advisors calls from great deference from the court, what the Supreme Court said, Bragg does not even try to rebut any presumption of immunity for official acts that were presented to the grand jury. Doesn't even try to raise it. Now, sufficiency and harmless error analysis do not apply to Trump's immunity violations. The requirement that prejudice may result from these violations is satisfied, as the Supreme Court explained previously, because this is likely to create a prospect of an executive branch that cannibalizes itself. And so in addition to the harm to President Trump, any failure by the courts to faithfully apply the presidential immunity doctrine will irreparably damage the presidency. These violations and harm the welfare of the community. They weaken the presidency. It's very serious, and so accordingly, the indictment must be dismissed. SCOTUS gave us a good basis for this. Now, the jury's verdicts also cannot adequately stand, and Trump has made his objections adequately preserved. Bragg does not dispute that they did lodge trial objections to official acts testimony. He knows we said it when they called Hope Hicks to testify and when they tried to get these forms admitted. But they wrongly contend that President Trump's other challenges are largely unpreserved. Wrong. Trump raised presidential immunity objections to the trial proof before and during the trial, including in the Court of Appeals. In fact, Trump says we raised it many times. In March, a pretrial motion sought official preclusion of all the official acts. So to keep them out before the trial even starts. They said, oh, Hope Hicks is going to come testify. Michael Cohen's going to come testify. And so it should apply to everybody. Now, after the court, Judge Merchan erroneously denied the motion based on some law he snagged out of his booty, President Trump sought a writ of prohibition in the First Department, tried to take this up on appeal. In that petition, Trump reiterated objections to this person, this person, this person, and this person doing these things. And the court was fully aware of President Trump's arguments in that proceeding as counsel for Your Honor entered an appearance and opposed the application. Wow. So the judge got a lawyer? Counsel for Your Honor entered an appearance and opposed the application. That's interesting. What's going on right there? Now, after the First Department, the Court of Appeals, denied the petition in a manner that's inconsistent with even its own case law, in this case called People versus Orstein, as well as the Trump Supreme Court case. They said, okay, we have immunity. Merchan said, you don't. They took it up to the Court of Appeals. Hey, we have immunity. Can you tell him we do? They said, no, you don't. I said, okay. So they were in violation of their own rules, their own case law. Then Trump came back down and renewed presidential immunity objections again during jury selection. Also sent another pre-motion letter. On April 19th, the court acknowledged that the parties had already made your arguments. The judge said, stop talking to me about it. You've already made your arguments. Trump also objected the first time that the presidential immunity issue arose during trial, when Hope Hicks testified. The court overruled. Objection overruled. He said, I believe I ruled on this. And he said, hey, defense idiots, you do not need to object as to each question. Okay, I got it. Stop objecting. Now, in order to make clear that President Trump did maintain the immunity objection as to documentary official acts, the defense objected to the form. Then Bragg incorporated by reference their since rejected arguments about immunity. The court issued a 2-word ruling saying, I agree. And for the avoidance of doubt, the defense renewed the objection to the Twitter post, object again, and they said no. Now, for purposes of this, nothing more was required. So here, the Court of Appeals found an issue to be preserved because there was a general motion to dismiss. Okay, like in other words, that's enough. What we did was plenty. On multiple occasions, they say the court was plainly aware of and expressly decided that presidential immunity did not exist. And so as a general matter, okay, in order to preserve a point, a lawyer is not required to repeat an argument that the court has definitively rejected. President Trump was not required to antagonize the court or to test your patience by saying objection, objection, objection every 2 seconds. Now, Bragg, once again, relies on another case that is distinguishable here. Doesn't apply. And presidential immunity errors are mode of proceeding defects for which preservation is not required anyways. For all these reasons, Bragg has not established any procedural bar as to why we can't review their violations. Now, continuing, they say Alvin Bragg also did not open the door to these immunity violations, saying Alvin Bragg in his reply and his response wrongfully claims that President Trump opened the door. So Trump can't say you got to keep this out because he wanted it in the form of 3 2018 tweets and testimony from Cohen about a congressional investigation. They say, come on, Bragg. The argument fails because Trump's strategic decisions about Cohen's lack of credibility were informed by the dismissive treatment from the immunity decisions. The only reason that we talked about any of that is because we had to, because you overruled us on immunity. If we would have had immunity, we wouldn't have gone there. Moreover, the only authority they cite is New York evidence rule. It's a relevant case law. The opening the door principle was limited in the Supreme Court case here, and so it just doesn't apply. Now, also, they're talking about removal proceedings. Have no bearing on this case at all. There's no authority for Bragg to say that Trump waives his defenses because he didn't raise them in a removal proceeding to federal court. Doesn't matter. Didn't have to raise them there. Saying the court's reasoning is irrelevant. And so nothing in that removal proceeding can be used to rebut any presumptive presidential immunity that Trump has, thanks SCOTUS. Now they continue in subsection D, saying, Your Honor, there is no public record exception to presidential immunity. Bragg says, well, maybe there's some immunity, but kind of there's an exception to it. Says, no, there's a footnote in the Trump decision where they're arguing that presidential immunity does not apply to evidence that consists of a public record of an official act. So this is a made-up exception, they say. It's refuted by the Trump opinion and common sense. There's a public record exception? What? Bragg elsewhere recognized that there are public comments that the Supreme Court indicated would qualify as official presidential conduct. Yes, because the president has to speak to the public. Bragg claims that they did not violate the presidential immunity doctrine by offering Trump's tweets because they admitted nothing more than a public record, right? It's not an official act of anything. It's just a public record. Well, if that were the case, then the Supreme Court wouldn't have wasted an entire subsection analyzing public statements, including tweets. They wouldn't have talked about the bully pulpit. They wouldn't have talked about the president's extraordinary power to speak to his fellow citizens. And so they're just seizing on this footnote. And in that portion of the opinion, the Supreme Court was talking about bribery prosecutions from Amy Coney Barrett. Bribery is a unique constitutional thing. There's a narrow meaning to that term for official acts. It's codified in the U.S. Code. At most, footnote 3 of the Trump decision stands for the proposition that federal prosecutors could, quote, point to the public record in bribery. Bragg to stretch that out to include and mean a bunch of other stuff. And this is fun. Bragg whiffs. Oh, that's a fun one. You can just picture Bragg just coming out there trying to hit a piñata or something, just whiffing, probably doing a full, 720 and falling over. Oh, man, I can see it here. Probably happened. Hope he's okay. Says he whiffs at a straw man in response to President Trump's reliance on Clinton, which confirms that the public statements on behalf of a sitting president are within the outer perimeter of presidential authority, even when they're about private parties in private matters. In the Clinton case, there was stuff about defamation, and they say the Supreme Court said that a state law defamation claim arguably may involve conduct within the outer perimeter of the president's official responsibilities. Yeah, look at that. So maybe this will even apply to the E. Jean Carroll case. I think it will. In Clinton, in other words, Trump's defense already has the citation. Okay, they already have the case cite. Supreme Court said arguably may involve outer perimeter for official responsibilities. That defamation claim was based on responses by Clinton to Paula Jones, issued by White House aides. The fact that 8 justices who joined the Clinton opinion believe the public statements by White House personnel in a private party responding to Jones were arguably within the outer perimeter. Oh, boy. E. Jean Carroll, Roberta Kaplan, George Conway having a bad day today. They're going, oh, I forgot about Bill Clinton. That President Trump's tweets and conversations with advisors regarding allegations of pre-presidency matters are not manifestly or palpably beyond presidential authority, right? The president has to respond to those types of attacks, which are in the outer perimeter under Trump. So even if the language from Clinton could be considered dicta, which we don't concede, dicta from the Supreme Court is not something to be lightly cast aside. That's fun. This is fun because Trump's defense, remember, in the other Jack Smith case, they're saying that dicta, Jack Smith's case in the classified documents case, he's saying that he has a lot of reasons to be appointed because of that one case, the Supreme Court case, that says, they sort of tacitly allowed special counsel to move forward. And Trump's people said, no, that's dicta. That's ridiculous. You just should totally ignore dicta. This is how the law is. That's why it's so fun. In one case, you're like, dicta's ridiculous. All right. We don't want any dicta around here. I'll tell you that. Okay. Get that dicta out of here. Dicta out of here. You know what I'm saying? So that's what they said in the Jack Smith case. But here they're like, well, dicta is pretty important. We're not going to concede that. We kind of want a little dicta over here on this one. You know what I'm saying? So therefore, Clinton provides powerful support for President Trump's arguments that Bragg's proof in the grand jury and at trial involved official acts. It's great. It's just great. This is good lawyering is how it works. So you just, different courts, different jurisdictions, different arguments. That's how it works. So here is the bad evidence that they admitted in Bragg's case. First, Trump's official communications with Hope Hicks. Bragg elicited testimony from Hope Hicks regarding official acts by President Trump, all protected, all immune. Specifically, Hope Hicks testified about her conversations with President Trump while she was the White House comms director, specifically about a Wall Street Journal article, a New York Times article, a CNN interview, which, just like Clinton responding to Paula Jones, outer perimeter, inside. President Trump's conversations were talking about then existing statements and allegations levied during the presidency by Cohen, Daniels, and the FEC. All presidential stuff. The Bragg cannot escape the presidential immunity doctrine by claiming that the subject matter of those discussions occurred prior to Trump's first term. He's saying, yeah, but they're saying that you did these things in 2016 or 2015. Okay, but they're talking about it as he's the president. That brings them inside the envelope. Otherwise, the president could just be attacked with everything else that came up before and couldn't respond. It would be ridiculous, right? Obviously, the president is going to come under additional heightened scrutiny and attack. So as with blank redacted, President Trump spoke about these topics with Hicks, a close advisor, pursuant to his core constitutional powers. He did so as part of his efforts to supervise Hicks and her work and to ensure that Hicks and her staff were prepared to address questions that were being communicated by the White House about Trump. The absolute immunity that attaches to these conversations is not based entirely on a government official's role. Rather, the immunity derives from the nature of the authority that President Trump was exercising. He has that power. Now, in this regard, Bragg did not address Trump's citations to the executive vesting clause in the Constitution, or to the take care clause, or to the Myers case, or to the SELA law that was referenced in the Trump Supreme Court case. These provisions establish that a president does have the power to use the bully pulpit to persuade Americans, including by speaking forcefully or critically in ways that the president thinks would be in the public's interest. The president can exercise this constitutional authority. And so because it is preclusive and exclusive and conclusive, Congress cannot limit a president's ability to speak to the public. Therefore, absolute immunity applies. And Bragg's suggestion that a president's internal communications advisor, that they're palpably or manifestly outside the presidential authority, is brazenly inaccurate. Their argument proceeds by ignoring Hicks's trial description of her job responsibilities. She said that she does everything. She coordinates all of the communication efforts for the administration, and that her job is to showcase the president in a good light. When compared to that testimony, Bragg's citation to another case is frivolous. Each of those scenarios in those other cases are ridiculous. They're like party fundraising events. That's not what this was. Trump did not speak to Hicks about these topics in 2018 as a candidate. He spoke to her as the president. Now, although it's true that the demands on a president's time may include some private matters, it's true, the testimony here that's based largely on media inquiries were all routed to Hicks through the White House. As part of this response and coverage on CNN, Trump spoke with Hicks so that she could be prepared. They were part of his official responsibilities, well within the outer perimeter, and Bragg's efforts to say these are private conversations is no support, even on the record. The facts that were presented at trial show it. So Bragg has not met any burden to rebut the presumption of immunity. We start with that thanks to SCOTUS. If the presumption of immunity exists, it applies despite a hostile prosecutor's conclusory assertion that official acts would not impact the president's official decision-making. To rebut the presumption, Bragg needs to establish evidence that would pose no dangers, right? That's not how this works. It's no dangers to the authority or functions of the executives. That's what the Supreme Court said. So with respect to the official internal interactions between the White House and the president, Hope Hicks, as well as Madeleine Westerhout, as well as this person who never came up at trial, the Supreme Court has recognized we have to protect these communications. And so Bragg cannot rebut the presumptive immunity that goes over to Hope Hicks. Madeleine Westerhout also was brought in. Bragg acknowledges, they have to, that the challenged portions of Westerhout's testimony concerned Trump's basic work habits, his work practices as president. Oh, bummer. As well as national security procedures. Remember her testimony? They brought her in, and she was talking about how Trump would call Melania when he was going to be late, talking about the Situation Room, methods of air transportation, all using official White House stuff. Now, there's no de minimis exception to trigger presidential immunity. And Bragg does not address Trump's argument that the immunity at issue is absolute because President Trump's activities were pursuant to his core responsibilities as the commander-in-chief. Bragg finds it, quote, difficult to imagine criminal liability stemming from general work practices, but that's exactly the type of evidence that Jack Smith got. Apart from that feigned lack of imagination, Bragg does not seriously dispute that Trump's decisions about how to run a White House were at least within the outer perimeter. It's like you're asking about his job, like specifically. So Bragg, as a rebuttal, offers irrelevant assertions. He was talking about the purpose of the testimony. It's not about what she said he was doing specifically. It's about the purpose. And it's about what mattered to prosecutor was this. And no, okay. But they cannot rebut presumptive immunity. It was invasive testimony about his daily activities. Claiming that the testimony is not going to influence any future president is not enough. Unlikely? No, unlikely is not the standard. You have to show it's no dangers. Yeah, they can't do that because any future testimony at a post-presidency criminal trial about the management style of the Oval Office would render him unduly cautious, right? If you're allowed to go in there and just, well, tell me about how you run your Oval Office. What? Some hack prosecutor can do that? No, it would it would be an intrusion onto the presidency, and the Supreme Court says you can't do that. Because the country elected that person. So we give him protections against hack prosecutors like Bragg and Colangelo. Now, they also brought in Trump's Twitter statements, saying that Bragg relied on evidence of 5 official tweets that Trump issued as part of his presidential communication. Even if the court extends the Trump Supreme Court decision to recognize presumptive immunity for outer perimeter official acts, Bragg has not rebutted the presumption described by the Supreme Court. In fact, contrary to Bragg, there is no requirement that a president's public statement purport to discharge some official duty in order for it to be an official act. Like, only if you say, I hereby declare as president that the following is true. Like, okay, that's official because you said that? No, public statements certainly can qualify as official, even when not obviously connected to a particular constitutional or statutory provision. In any event, 2 of the tweets reference ongoing investigations and therefore did relate to the president's core official duties. These tweets touched on the investigative and the prosecutorial decision-making, which is the province of the president. And so therefore, Trump is entitled to absolute, unrebuttable immunity with respect to at least these 2 tweets. And context also matters. Remember, the Supreme Court said that in the Trump case. They say that for each of the challenged tweets, President Trump used an official communications channel of the White House. There were White House employees involved, Madeleine Westerhout, Dan Scavino, shout out to both of them, to address matters of public concern on the X account. Thus, President Trump's position is supported by other case law, which says that an official who uses government staff to make a post will be hard-pressed to deny that he was conducting government business. Now, the fact that the tweets also reference Cohen and Daniels did not render them unofficial. Most of the president's public communications, they say, are likely to fall comfortably within the outer perimeter of his official responsibilities, especially where the presidential communications address current matters of public concern. Daniels, Stormy, described in a 2018 tweet by Trump, he was responding to false public claims by Daniels and others. This other exhibit was about a widely covered FBI search targeting Cohen, another matter being publicly investigated at the time, which Trump oversaw. This was about Trump's guilty plea, similar to the media activities where Trump discussed with Hicks, even if underlying historical allegations were private and pre-presidential, these public tweets concerned developments when Trump was president. Nothing in the Supreme Court says that it's limited to pressing policy or public emergency. None of it. And a prosecutor's ex post determination after the fact that a national voice was not needed at the time is not enough. The tweets were arguably at least within the outer perimeter and not palpably outside the outer perimeter as defined by the Supreme Court. So, although immunity attaching to these tweets is absolute, any efforts to rebut the presumption of immunity is deeply flawed. The presumption would apply because Trump issued the tweets pursuant to his official authority to do that. It's therefore legally inaccurate and a non sequitur to claim, as Bragg does, that the tweets bore no relationship to any official duty of the presidency. No. The dangers of intrusion on the presidency are apparent here from Bragg's own words, that future presidents will be concerned that their public statements may be used as evidence in criminal proceedings. And those future presidents could take no solace in the fact that Bragg casually reduced Trump's statements to personal opinions. No, it's not. That's his opinion. Their argument boils down to a claim about tweets being motivated by a private purpose. And you can't talk about motivation. Supreme Court said so. So Bragg's entire logical underpinning is invalid. Thus, even if the presidential immunity relating to the tweets could be deemed presumptive, Bragg has failed to carry his rebuttable burden. So Trump is immune there. And also, Trump responded to the FEC inquiries. They used that as evidence in the trial. Trump is protected, they say. Trump, in fact, used his exclusive authority under the Take Care Clause to address the decision-making at the FEC. Bragg blatantly ignores the Supreme Court decision, arguing 3 separate times, in fact, that Trump's actions in connection with the FEC were not official because in their view, Trump intended, right, motivations, to interfere with the investigations. First of all, they falsely characterized Trump's motive, and by the way, intentions are irrelevant. The text messages involving Cohen and Jay Sekulow reflected decisions by Trump in response to FEC inquiries. He was the president. Those were in the outer bounds of the presidential authority, and you can even go back to the Clinton dicta if you want. In addition, Bragg plainly wanted the jury to infer that Trump spoke to the AG about the FEC. The inference pursued related to an absolutely immune official act, and so Trump is protected. No part of the Supreme Court decision places a burden on Trump to acknowledge whether he actually ever did that. The mere suggestion of such a defense burden is further evidence of their reckless and untenable approach to this case. Whether or not the conversation happened doesn't matter. It violated the immunity because it concerned a conversation Trump is protected under. And to the extent that the court applies presumptive immunity here, Bragg doesn't even make any effort to rebut it. Similar to Madeleine Westerhout, Bragg misstates their burden by saying it's unlikely to impact presidential decision-making. That's not what the Supreme Court said, unlikely. It's not the rule, Bragg. Compounding that error, Bragg again invokes impermissible arguments regarding motive and intent. Not allowed to do that. Said Trump was just being gratuitous. The prospect of prosecutors seeking to imprison a former president by using his own exercise of discretion would impermissibly intrude upon his discretion. They can't go into his brain and decide what his motives are. And presidents, if they were allowed to do that, would have valid concerns. Now, they also brought in other evidence. Michael Cohen testified about Trump's public message in response to congressional investigations, saying there was no Russia, Russia, Russia. Bragg did not even address the explicit recognition of presidential authority to engage with Congress, nor is the presidential immunity violation excused by Bragg's argument that Cohen brought this up only because he was trying to justify his own reasons for lying to Congress. So, in other words, there's a proper reason to bring this in. It's because Cohen's a liar. Yeah, that's really wild from a prosecutor. In addition, through Cohen's reference to pre-pardons, Bragg sought a highly prejudicial and inaccurate inference relating to the alleged use of a constitutional pardon. None of that should have been allowed in either. And similarly, this form, OGE form, saying it rests entirely on this public records exception, and none of this was harmless. Self-serving explication of the trial record can't save Bragg from the fact that their entire case turned on Michael Cohen's credibility, which was severely lacking. Bragg concedes that the official act's evidence was presented to bolster Cohen's weakness. That's why they emphasized it. Supreme Court warned about this, saying it raises a unique risk that jurors' deliberations will be prejudiced by the views of the president. And so jury selection demonstrated that was a risk in this case. It cannot be said that these errors were harmless. They were catastrophic. More fundamentally, harmless error analysis is not even available to Bragg. These are immunity violations. These are structural errors. This is a New York mode of proceedings problem. Prosecutors could violate this doctrine And so harmless error review would eviscerate the immunity. Just, it's not that big of a deal. It's just harmless immunity. We would have gotten it in any other way. We say these are structural errors because we are protecting the institution of the presidency. Separation of powers. Bragg cannot say this doesn't matter. Immunity errors are too hard to measure. And so these violations were mode violations. And so in conclusion, the court, Merchan, should dismiss this indictment and vacate the jury's verdicts, all 34 guilty findings on violations of the Presidential Immunity Act and the Supremacy Clause, signed by Todd Blanche and Emile Beauvais for Trump's defense, submitted to Judge Merchan in the New York Alvin Bragg prosecution, state of New York, and submitted by the defense. So we'll see what the judge has for us in response. This was the affirmation of Todd Blanche, and this has landed on Merchan's desk. And so we'll see when we get a ruling from him. Of course, we're not expecting anything anytime soon. We know he's giving us until at least September to decide where he's going to go on this. So we'll continue to cover it, my friends. Thank you for subscribing as we do, and we'll look forward to seeing you back here on the next update on the next one. All right, and so that's a little Alvin Bragg update. We got New York well covered today. Now let's turn our attention over to what's happening with some of this assassination news, because we've got Josh Hawley with a new letter and more. So let's get this queued up over from CNN. Local cops pushing back on the Secret Service, saying that they are the ones painting a misleading picture on what happened on J13. Misleading is their word. We'll call them liars because we've already seen them do that many times thus far. But the story is from CNN. We also have whistleblowers, including one who communicated to Josh Hawley that they are telling us the new acting director, Ronald Rowe, personally cut agents for events. So did he lie to us in Congress? Remember, that was the same guy who blamed the local cops. He brought out those poster boards, as we talked about last time, and was saying, why didn't they just look left? CNN apparently sat down, talked to some of these guys, saying that the Secret Service is presenting a misleading picture. They got blamed, man. The Secret Service threw them over the bridge, like they did with Joe Biden almost. Here they tell us Pennsylvania law enforcement officials are accusing the Secret Service director, Ronald Rowe, of misleading the American people by saying that local snipers at Trump's rally should have looked left. I couldn't even believe he said that. And spotted would-be assassin Matthew Crooks with his poster boards. Why didn't they just look? I lose sleep over this. I don't know. I know the guy who shot him in the head. We're friends. He sent me a text this morning. Okay, relax, Ronald. Beaver County District Attorney Nate Bible and Detective Patrick Young, head of the Beaver County Emergency Services Unit, told CNN in an interview on Wednesday that the Secret Service had not reached out to Beaver County snipers to speak to them before Rowe made his accusations at a nationally televised Senate hearing this week. Piece of work. For the acting director to say that this is where our guys were and this is what they've seen is a misrepresentation to the American people, as we suspected. We were never asked what we'd seen or where we were from Secret Service. I can tell you that again. The pictures presented is a misrepresentation. We'll call it a lie. Another one. They lied about sloped roofs. They lied about who was covering what. They lied about showing up at the meeting. Many people say that there was a total rejection of agreeing to certain services. Local cops saying, we can't do that for you. Then they brought out a poster board and lied about the poster board. Can you believe the Secret Service would do that? Yeah, obviously. No records, logs, call logs, radios all gone. Lie, lie, lie. Then they blame the local cops. It's sick, man. It's sick. The Secret Service is falsely trying to blame other law enforcement agencies for the failure to stop crooks, says Bible. Before this incident, he says, I would have thought Secret Service is like bulletproof. I mean, you're not getting within 50 yards of somebody important, even on foot, right? Let alone, a sniper or something. You're right. It honestly seems like, they don't have answers. So they're just kind of pointing fingers and passing the buck around. Yeah. Bible and Young said that they are taking the criticism from the Secret Service personally. They should, because it was pretty damn personal. And warned that the trust between law enforcement agency has been fractured. Trump has said he plans to rebuild Butler, Pennsylvania for another rally, but the county officials say they haven't yet heard from Secret Service or the campaign about any future plans. The Beaver County officials were part of a multi-jurisdictional team assisting the Secret Service for Trump's July 13th rally. Rowe's testimony and photos he showed to the lawmakers of the site has further exacerbated the tensions between local law enforcement officials and the Secret Service. It was wild. He was pointing their fingers at him, blaming them. I didn't do it. I'm not responsible. We're not responsible. You're the Secret Service, bro. Having played out in the days since crooks climbed onto the roof, the Secret Service has not responded to questions or comments. Asked if he could confidently say that something like this would not happen again at a future rally, Young said, I cannot say that, no. At this point, me, along with I'm sure the majority of the American people, we have many questions as to what and how the Secret Service does their job or doesn't, or intentionally enables someone to be shot, bring them out to be shot. And I would have never said that before this week of rally. With testimony, because the Secret Service has not acknowledged for everything that they say that they did wrong, there's a but, and that but follow is usually assigning the blame to local law enforcement or to state police. Secret Service declined to comment. Federal law enforcement official familiar with the matter said the Secret Service was and has been in touch with the lead for Butler Emergency Services units, and they're like, they must be just furious. We said that yesterday, man, when we were going through this. Those local cops, man, must be fuming and furious. We said that as we were going through that the day of. And they are, obviously. They should be. It was insulting. It was reprehensible. But it's what our cowardly bureaucrats do. Somebody else is responsible for this. Who oversaw the county. The official said that the counter sniper team was able to take pictures of crooks. And there's a dispute over the ability to see this guy. During the Senate briefing, Rowe highlighted the failures of communications. Said that the information was siloed and stuck in local law enforcement channels. He also said that local law enforcement was positioned in a nearby building and should have had a clear line of sight over crooks. Claims that Beaver County disputes. Rowe said, I cannot understand why there was not better coverage, or at least somebody looking at that roof line, when that's where they were posted. Looking left, why was the assailant not seen? But Young asserted that the photos that Rowe displayed at the hearing could not accurately capture the vantage point of the snipers in the buildings. The snipers had been instructed to be covert, meaning they could not stick their heads out of the windows, right? You're back in a window, you can't see, you have a much narrow angle. The photo the Secret Service used show its viewpoint was taken through a window that had been secured and was closed during the rally and only opened after the shooting had taken place. Oh, man, the Secret Service poster board was a lie. Lie. Unbelievable. And he spent $35 on that thing, and it took a whole afternoon to get it into the building without crinkling one of the corners. The photo the Secret Service used to show its viewpoint was taken through a window that had been secured and was closed during the rally. They just opened it, stuck their camera out, and they're like, I can't believe he didn't see that. You guys are so irresponsible. When our people were, was the far right side of the AGR building. Their views in no way could have seen crooks without pushing their heads outside the window and looking back. The videos in the exhibits presented to Congress are purely wrong as to what they'd actually seen. Lying Secret Service. Young and Bible said that they are speaking out to both correct misinformation and that has come out in the days since the shooting, such as the false claims that the snipers were positioned inside the building because it was too hot to be on the roof, and to combat public statements that have thrown local law enforcement under the bus. They're like, we don't care about the heat, a-holes. We can walk on sloped roofs, you jerks. It's extremely misleading to the American people. These are bona fide cops who were there. I mean, it makes our guys look incompetent to me to say, oh, well, all you had to do was just turn your head to the left. You would have saw this. My reaction was I was a little fired up. Yeah, I could imagine. We were fired up. I was like, man, I wasn't even there. I'm fired up. Like, holy crap. They're talking mad garbage on you guys. Yeah, and they're blaming you for their responsibility. They're like, hey, can you please help us? We're in charge. You show up to help, and they say, thanks for getting someone killed. Wow. Thanks for your gratitude. Snipers were told to look at the crowd area, officials say. Bible also added that there were screens on the windows where the snipers were stationed in order to keep them hidden. The muzzles of the guns were about a foot behind the window, Young said. The snipers were about 3 feet back, observing through the window with binoculars. The screens were allowed to be in place because then it allowed us to shoot through it, but people would not be allowed to see in. What they were instructed to do, and who instructed that? Was that Secret Service instructing them? Or was that local? What they were instructed to do was focus on the secured area in front of you. So before you went in through security, immediately after, before the stage, watch those individuals. Make sure nobody snuck in something past security. Not to look at the outer unsecured area where Crooks was. And so even if that was their job in that position, they couldn't have seen it. They would have had to have been outside that window. One of the Beaver County snipers took a photo of Crooks before the shooting, shared it on a text chain. Young said the sniper called in what he had seen to his command center, though he did not know if that information was ever relayed to the Secret Service, and they were supposed to be in the same room. We also saw that Colonel testify to Congress that there was another man, there was a local person and a Secret Service person in the command center so that they could verbally relay and communicate. I can't attest to who was in that command center or what visibility Secret Service would have had at that point. One Beaver County sniper called Greg Nickel left his post to search for Crooks through other windows in the building, Young said, though he said that the Butler sniper there remained at the post, unlike what had been suggested in prior testimony. So both the snipers didn't leave, one stayed, one left. Bible credited Nickel with potentially saving lives at the rally because of his early identification of Crooks as being suspicious, taking a picture of him through the screened window and sending it around. Oh, that's why that photo was a little wonky. There was a screen. If it wasn't for Greg Nickel identifying Crooks so early on, that is what allowed the Secret Service sniper to immediately take him out. You know, he did get 8 shots off otherwise, but otherwise he could have potentially have unloaded a couple of clips before they knew where the guy was. So local cops are saying, we'll say it for them. They can't say it. I understand that the Secret Service lied. Liar, Ronald wrote. Spent all of our tax dollars, probably on $700 poster boards, all for a big, phony lie. Not a surprise. Now we continue on. Whistleblowers from Josh Hawley's office say that Ronald Rowe directed the cuts to the U.S. Secret Service agents who do the threat assessments for events. Whistleblowers says that those agents were not present in Butler, and some of them had warned about security problems for months. Here's the first part of Hawley's letter, telling us, all right, acting director Rowe, liar. Since your testimony before the Senate, new and disturbing information has come to light about your planning for Butler at the campaign event and your own involvement in this. A whistleblower has alleged to my office that the Secret Service Counter-Surveillance Division, CSD, the division that performs threat assessments of event sites before the event occurs, did not perform its typical evaluation of the Butler site and was not even present on the day. Who would make that decision? This is significant because CSD's duties, like their entire job, include evaluating potential security threats outside the security perimeter and mitigating those threats during the event. Now, the whistleblower claims that if personnel from CSD had been present at that rally, the gunman would have been handcuffed in the parking lot after being spotted with a rangefinder. That would have been it, which is kind of what you expect, right? That's how I thought of the Secret Service. Like, you go to a rally, like, you don't bring in anything. Like, you have a Swiss Army pocket knife, just leave that at home, okay? Don't bring anything with you. You don't bring anything that even looks questionable, right? This guy comes in with a rangefinder. They're like, well, whatever. You acknowledged in your Senate testimony that being spotted, that American Glass research should have been included in the security perimeter for the Butler event. The whistleblower alleges that because CSD was not present there, this manifest shortcoming was never properly flagged or mitigated. So the whistleblower further alleges that you, Ronald, personally directed significant cuts to CSD up to and including reducing the division's manpower by 20%. You did not mention this in your Senate testimony when asked directly to explain manpower reductions. And so the whistleblower also alleges retaliation against those within the Secret Service who expressed concern about the security at Trump's events. Aha. The whistleblower claims that following an event with Trump at a golf tournament in August of last year, Secret Service personnel present expressed serious concern that the Secret Service's use of local law enforcement was not adequate for security needs. We made this point a while ago. Local law enforcement were not properly trained for the event or otherwise prepared to execute the tasks given to them. Further, Secret Service personnel expressed alarm that individuals were admitted to the event without vetting. That's what we asked about. Secret Service is just like, yeah, just get some bros and come secure the event. We don't care. Like, okay, you're just gonna put snipers on the roof with Trump coming out? As long as some local cop says it's fine? With all due respect to local cops, but is anybody checking? Or are they just gathering guys together? So, there's a guy on the roof, whatever. The whistleblower alleges that those who raised these concerns were retaliated against. Insane that this would be the case, that this is our government. This is how they secure somebody. But here's what Holly wants. All responsive records during your time about policy and personnel changes. Also want to know the nature about your involvement in revising and updating this stuff. The number of Secret Service agents. We want to know how many raised concerns about these security practices and who was disciplined for this, as well as the nature of other concerns and the types of disciplinary action that occurred. I want to know the breakdown of the Secret Service personnel who also were there at the J13th rally by division and unit. I will await your response. Sincerely, Senator Josh Hawley. Now, this was another very interesting video that came out from Brian Glenn, and he just dropped this on X. And so let's do a repost on this puppy so you can follow him if you're following along at home. He said, look, I witnessed President Trump get shot in the face in Butler. This is my video from J13, and you can clearly see Secret Service have eyes on Thomas Crooks as Trump took the stage. Secret Service knew Crooks had a gun, was a deadly threat to Trump and the crowd, and they still let him walk out. Here's one video. He says, as you can clearly see, Trump is taking the stage. Says Secret Service has eyes locked on Thomas Crooks, so we're going to watch for this zone. As a journalist, says Brian Glenn at Brian Glenn TV, says, I've covered hundreds of Trump events and have seen this event and have seen his events delayed for various reasons. They delay for weather, man. Trump should have never been allowed to walk on that stage, but they did. So let's watch this together, and we'll mute this for the music, and just let's watch this together. You can see beautiful American flag. Trump comes walking out, and when we pause this right here, Trump is here walking out. This batch of counter snipers right here on the roof. That guy's looking through binoculars or some sort of a rangefinder there. Now this video picks back up. They're looking over there. They're looking directly. I mean, it looks like that building is probably based on where he's at. Maybe at his 1 o'clock, 2 o'clock, 3, not his 3 o'clock from that angle. That's too far. Probably his 1 o'clock, or maybe directly at it. I mean, it might be his 12 o'clock. 12 o'clock, 1 o'clock, the building is right over there, right? They just brought Trump out. That's Secret Service. So the video continues on, and our man pans over a little bit, and you can see snipers on the roof looking that direction. Trump walks right out on stage. So the timing is extremely sus. And here is a still shot of what it looks like. They're looking that direction. Are they communicating? What's he looking at? At the start of this, what is he looking? What are they looking at? This guy looks like he's probably looking directly at the building. Trump is even looking up at this screen over here, right? This direction. You can see his face. If I move my fat head out of the way, you can see he's also right there looking up at the scene. So when you compare and contrast that with this other video that has now dropped, Milk Bar TV has been doing some good stuff. They say, watch this incredible new footage of crooks placed in the timeline of the Trump shooting. And so let's play through this a little bit.
He's a valiant fighter. He's a great,
you can see the clock at the top. So there's crooks now at 18. So at 6:08:40. Remember the shots go off at 6:11, about 34, right? The first shots. So at 18:08:40, we've got several minutes, about 3 minutes. Crooks is now crawling along the roof. This is the timing of it. So 18:08:36.
He's a valiant fighter. He's a great, great gentleman. So we're going to bring him up for
Crooks running across the roof.
All right. You get ready, McCormick. You get ready. I'll get you up here.
There's Crooks.
The world will see a vibrant Republican Party that is bigger, stronger.
Fast forward several minutes.
Yeah, someone's on top of the roof. Look.
Thank you.
There he is right there. Right there. See him? He's laying down. See him?
Yeah, he's laying down.
Laying down.
And
Secret Service is still just jerking around.
with you fighting like hell to get a senator elected and to make sure we take back the White House, because if we do, we're going to make America better than ever before. We're going to make it.
Yeah, look.
And it's not easy, because we have millions and millions of people in our country that shouldn't be here. Dangerous people, criminals. We have criminals. We have drug dealers. We have people that should not be here. And it's much tougher than if it happened. We had the strongest border ever.
Got a gun. He's got a gun.
If you want to really see something to take a look at what happened.
All right, so we know what happens from there, right? The gun now goes off and shots are fired, and then he is taken out. And so just making sure the rest of this is blurred out here, and it is. So here is how the rest of that goes down. Trump drops.
I hope he's turning this way. Be careful, guys.
There it is. So you can see, I think the point of this video, man, every time I watch this, it's like, gives me chills. Like, oh my gosh. Oh my gosh. It was so close. I can't even believe it. Anyways, yeah, it's insane. So 18:08, 37, Crooks is on the roof. 18:08, it's all synced up. This video is so outstanding. Shout out to Milk Bar TV for doing this. We're going to repost this on our X so you can follow along at home. Make sure you're following them. 18:08. So Trump is up there. Shots go off at 18:30. First shot about 18:33, 34. There it is, right? 18:30, 18:11:33. So we go all the way back. Crooks is on the roof, synced up with the speech at 18:08:45, 6:08:45. Secret Service, as we saw before, watching him. Crowd watching him. He gets up there, fires multiple rounds. I don't know how else you say other than this was allowed, intentionally allowed to happen. So, absolutely outstanding. Make sure you're giving this account a follow. My gosh, what a great mashup here. Incredible footage. When you place it all together, they were just allowing him to get into position for multiple minutes. We also have reaction from the Secret Service team. They say that they were put on the ground level. Secret Service instructed the local counter sniper team to set up at the ground level, not an elevated position. So here is a little bit more of this commentary, originally clipped by Charlie Kirk.
In those first two windows.
So he's wrong about the assignment.
Absolutely.
I think the biggest thing to not lose sight of is, their job was on being on the outside unsecured perimeter, looking inward at those, that had already gone through security.
The local officials told Fox this was the view their two snipers had. You can see this is a different warehouse window than the one Rowe pointed to, and the vantage point is at the ground level looking into the crowd and not onto the roof. The commander of the local snipers says if the Secret Service had told them to place their snipers on the roof, they would have. Acting Director Rowe says he takes full responsibility, though, and they will be more forward and direct next time with their local counterparts. We've reached out to the Secret Service about what local law enforcement officials are saying here on the ground, and they directed us back to Rowe's congressional testimony.
Unreal. The Secret Service are just lying. They're just lying now. And the local cops are saying they're not telling the truth. We'll go ahead and call them liars. Here's what Rand Paul said. Feels like there is a cover-up network underway here. Rand Paul and Maria Bartiromo were talking about
tell
this.
Us that nobody had whatever. Meta and Google nation attempt on his life, assassinations.
Let's see, is Rand Paul in here?
There it is.
How terrible.
There's Rand Paul.
Well, all I can say is thank God for Elon Musk, who exposed how terribly biased these people were. And by taking over Twitter, Twitter now is an objective platform where you can post things.
All right, so that's Rand Paul and Maria Bartiromo. But the Secret Service obviously filled with liars. And it's amazing that they have tried to point the blame at these local cops. These local cops obviously have to stand up for themselves. We're glad to see them doing that.
Now, we spoke specifically with some Beaver County officials who led some of the SWAT and sniper teams who were on the site of that Donald Trump rally earlier this month. And they were particularly frustrated at the suggestion by the acting director of the Secret Service that all one of their snipers had to do was simply look to their left, and they might have seen crooks before this attack happened. Take a listen to their response. One of your snipers looked left. Was it that simple?
It was absolutely not that simple. And the first thing that comes to mind is that
punks?
We have not had any contact with Secret Service. Actually, since the last election cycle, we post-incident or pre-incident, our snipers or our team has not had any contact.
Wild.
For the acting director
they were set up too, man.
To say that this is where our guys were and this is what they seen is a misrepresentation to the American people.
Sick.
We were never asked what.
Sick. Look at that. Look at that image that they put up there. They are sticking their head out their windows. All right. Like, I didn't even pay attention to that when we looked at the photo originally, but yeah, like the camera is out the window. Like literally hanging out the window. So obviously a sniper wouldn't be positioned there, right? Even if you step back a couple feet and just look out, you're only going to see this area, right? It's going to cut off this whole roof. And they're probably presuming that the Secret Service had the roof covered from the other angle.
Or where we were from Secret Service. I can tell you that the pictures presented is, again, a misrepresentation. Where our people were the far right side of the AGR building. Their views in no way could have seen crooks without pushing their heads outside the window and looking back. The videos and the exhibits presented to Congress are purely wrong as to what they actually seen.
Former President Trump said that he plans to have a rally back in Butler County. Can you confidently say that something like this will not happen again if that happens?
I cannot say that. At this point, me along with I'm sure the majority of the American people have many questions as to what and how the Secret Service does their job. And I would have never said that before this week, really. With
Sick. Secret Service pointing the blame at local cops who are only showing up there to help. And we'll see, I guess, what happens with Ronald Rowe. Is he going to resign and go join Kim Cheadle and Nathan Wade on their cruises? We'll be here continuing to cover. Thank you for joining us, my friends. Thank you for subscribing to our channel, wherever it is you're watching it, and we'll look forward to seeing you back here on the next one. All right, my friends, now it's time to hear from you. Let's see what you say about this. If you're just joining us, we had 3 good segments on the day. We talked about Judge Merchan. Trump and his defense have filed a request for another recusal on Judge Merchan. He needs to go because his daughter works for Kamala Harris, and she's now the nominee for the Democrats, which raises a whole new slew of issues there. So we covered that. We also went through the immunity reply from Trump's defense, saying that the Supreme Court decision says all those 34 convictions have to go bye-bye there in New York. And then, of course, we had a pretty interesting assassination update because the local cops are now fighting back, and we're happy about that. So let's see what you say. And as always, thank you so much for your support, your super chats, membos. We very much appreciate it. Couldn't do it without you. And let's jump in and see who's in the house on the day. We had some nice new supporters join us. What's up, Linda? And if you're a new membo, we had a great members only morning stream this morning. We talked about the aftermath of the Trump National Black American Journalist event. It was an interesting stream because I was trying to, I'm just a white guy. I don't know much about anything, obviously, because I'm just a white guy. But we were trying to understand, what is enough blackness? I don't know. What is enough? I hate to even say it, but that's what we were talking about this morning. Trying to figure it out because Karine said that we can't question Kamala's blackness and anybody can identify however they want. So then we thought about Rachel Dolezal, who is apparently 0% black, and she's fraud. So that's what we were trying to see. So, okay, so that is clearly not. That's fraud. What is 25% or 50% like Obama, or how does it work? We don't know. Maybe we'll get some instruction on that one day. But we're trying our best here. Hey, it's the Munkets. What's up? Bringing in 5 new membos. I don't know what the percentage is. Does anybody know? Tony Hey Munkets gifted 5 membos. Laura Haley's coming in. Tater Tots is here. Chris K, Marius B, and Matt M gifted membos courtesy of Tony Hey Munkets. Hey, it's the Munkets. We got Rick D's in the house, bringing in new membos. Azakis here. What's up? Pamela N. We got Taffy Smith, Cheryl P, and Rick Raguso in the house, courtesy of Rick Donner. Good to see you, Rick. Thanks for doing that, bringing them in. And new membos, grab that membos only morning stream. We got this one from K Bean. 10 membos coming in. What's up, K Bean? Good to see you. Thanks for being you, K Bean. We just love K Bean here. She's a mods down the fort for us and brings in new membos. Does it all. Bart Man XOXO coming in. My bet. No mandates, not a Fed. That's good. Steph Art is here. Eric Lawson, what's up? Zip Nails. Philippa C. Peter Uri. Lethal's here. And Philip H. Gifted membos, courtesy of K Bean. K Bean? Another 20 membos from K Bean? Oh my gosh. Look at this. K Bean. Thank you, K Bean. And welcome aboard, new friends. Courtesy of K Bean. The long and short of it coming in. Jittery Hobos here. Demon J, Kevin Murphy, Jules, Deb Shaw, Mad Mike, Jay Jarvis, Pink Husky. Rodney's coming in, along with Raven, Lamont Storm, CV Grady, J Dubs, Sherry P, Deep Surface, Brian C, Jim Gerard, Cassie Fairless, and G McGee in the house, courtesy of K Bean. Thank you, K Bean. 30 new membos. Welcome aboard, new friends. And grab that morning stream and say thanks to K Bean. Grab the morning stream and say thanks to K Bean. There we go. Hey, Tony Hey Munkets gifted 1 membo. Peggy Griffith, welcome aboard, Peggy. This old guy says Merchan should be removed as a jurist, not because his daughter is a Democrat enabler, but because he has used his office corruptly to enable his daughter's business endeavors. Yeah, and he's got a real clear conflict there. She was using this trial in her Facebook ads, literally, saying Trump got convicted and so on and so forth. Commingling the 2 items. William Wedding, what's up? Welcome as a new supporter. Grab that membo stream. Thank you, William. Hey, John McGarvey's in the house. John McGarvey bringing in JAC Eastridge. We got Leisha Luker, Billy Rice, JD here. We got Cheryl Pemberton. Is that JD Vance is here? We have Salty. What's up? Beautiful Crazy. Bobby McKenzie and Laura Soto, gifted members, courtesy of John McGarvey in the house. Thank you, John. John, always also extremely helpful, and we love John. This one from this old guy says, I caught this morning member stream on replay. First of the month is always a super busy morning, totally. And says, and I have a question. Okay, let's pretend for a moment that I'm a black guy who believes firmly that there is such a thing as white privilege. Oh, this is complicated. I don't know if I'm going to be able to ask another one. Can I self-correct my situation by identifying as white? Oh, yeah, that's a great question. Yeah, because Rachel, I don't know. I don't know how that works. I mean, I guess as a white guy, am I supposed to know the answer to that as a white guy? Like, should I know what percentage is? It feels very strange to me. See, we were asking ourselves because here's what happened. This woman called Rachel Dolezal said that she was a black person, and turns out she was not, like 0%. Okay, both parents were like, you're definitely white. But she fooled a bunch of people. She was like the president of the NAACP somewhere or something like that. Like, you know, it was like African studies in Harvard or some college or something. It was really weird. But I don't know if it works in reverse. So like they threw her out. They're like, you're not black, get out. But I guess if you wanted to become a white guy, I'd be like, well, whatever. Yeah, I mean, we really don't have any privileges or anything. Like, we can't even have groups or anything. They're like, you're Nazis if you have groups. So, like, I don't know. It's like, yeah, come have our gobs of privilege. Come enjoy. Like, I'd be like, yeah, fine, whatever. I don't care. Fun. What are you going to get? What's going to come from it? What are you going to get? Like, apply to a college. See how that goes for you. Yeah, right. Here, have all the white privilege in the world. Here, come take mine. Have some fun. Don't even have free speech. You get censored all over the internet. Yeah, enjoy. So, all right. Anyways, that's a funny comment, this old guy. Hey, what's up? Alice Elizabeth says, polls show that Kamala is most vulnerable in her ability to lead. We need to insist that she go to the Middle East to show that she can or cannot do what she can and cannot do. The world is going to poop, and Kamala is having little rallies. She told somebody to stop privately, and something escalated. We give her a pass on her leadership, so someone needs to pressure her to be the commander-in-chief. Well, I think it's curious. I'm looking forward to her to just answering like any question at all. She hasn't answered like anything. She just gives little scripted speeches and then runs away. NY says the media is cheerleading Harris. Also, be aware of the Mark Halperin podcast two-way. YouTube is pushing that to me. Mark Halperin is biased blue. We have to be aware of the media's attempt to fool us with fake bipartisan platforms. Yeah, Mark Halperin. Well, he's been right on some stuff. I mean, he's, I think, a pretty good reporter in journo. Patriot Rob says, what really cracks me up is that they are all tipping that Trump may or may not have said Kamala's DEI hire, but they can call him Hitler. Yeah, they can call Trump whatever they want. They can make terrible terrible things about him. And if he responds even a little bit or defends himself, then it's racist or bigoted or misogynistic or whatever. Hey, it's Bruce Rice in the house. What's up, Bruce Rice? It's Rice, baby. What's up, Bruce Rice, baby? Bringing in 20 new members, including Anthony Cunningham, Chris Sawyer. What's up, Mike Sue? Juju Queen is here. Ulsterman, Oz M. We got Coral Wright. He is coming in. Stephanie Panis. Paul Me No. We got Jesusa Gonzalez is in the house. Joyce Marine. Anthony Cunningham. What's up, Carl Miller? We got Established 1992. It's a good year. Great year. We got True Seeker Human. Sao Nami. Stephen Eddy. Tony Haymuckets shouting out. What's up, Mark Woodruff? Squatch Girl in the house. CL, Missy, and Jennifer. We got a bunch of new membos. Bruce Rice baby. Bringing in new membos. Thank you, Bruce. Thanks for bringing them in. Jack Mack, what's up, Jack? We love Jack Mack. Hey, Jack, thanks for being a membo and bringing in 5 new membos. Look at this, my friends. Julio, I'm too tweaked not to be a membo, you're not. Amiana List, 24/7 live AZ Skies in the house and Scoop in the house because of Jack Mack and her amazing generosity. We love you, Jack. Thanks for that. Hey, what's up? Chad Preston says, love you, Rob. Love you back, Chad. Thanks for that one. E. Texley is here, says good logic. Said that when he first met with the judge about his ungagged Trump filing, there were two other lawyers in the room, one for Bragg, one for Mercon. Interesting. Yeah, somebody's representing him. But was that for an appeal or was that... Yeah, that's right. Okay, that is right. That makes sense. And thank you for that, E. Texley over on the Rumbles. What's up? We had this one from Jeffrey Adams. Says we had 4,700 people watching here and only 123 likes. Come on, man. No, I'm serious. Hit the like button. No, I'm serious. Come on. Hey, thank you for that, Jeffrey. We got Don Goff bringing in 5 membos. Don, you're the man. Thanks for this. Lauren Wimberly's here. E.T. NY Renal. We got Joel V. Reyes in the house and PLM Productions all coming in. Gifted membos. Courtesy of Don Goff. Hey, look at this one from Flagpole Guy. Flagpole Guy sharing this one says, too hot outside today, so I dicked it around inside. Dun, dun, dun. What's up? Thanks. We're on the big screen over there. Hey, shout out to our friends at the Flagpole Warehouse headquarters, Flagpole Warehouse. 1776, baseball, hot dogs, cherry apple pie. God bless America. Amen to that. Good stuff. Jennifer says, hey, this is a good recommendation. Says, after Rob's show, please join Off-Label Podcast tonight. It's Thursday. Always a fun time. Sounds like a great recommendation. Jennifer, are you going to be on there? Is something going down tonight? I think so. Well, you're going to have to find out. Go check out Off-Label Podcast tonight. It's going to be great. Sandy says, the redactions look like grand jury witness names. Using them in a grand jury should cause a dismissal. Yeah, I couldn't tell if they were grand jury names. I think some of them were witnesses. Some of them were actual witnesses that didn't get used at trial, but may have been used. But they were, in other words, they were used in the grand jury presentation, but not used at trial. So they were in the records at the prior proceedings, so we couldn't talk about them because they were not actually made public, I think is what we saw. Goofy for Jesus says, it is so expensive to combat garbage lawyering. Oh, gosh. Tell me about it. Lawyers, man, very expensive. You don't want to, hire lawyers if you can avoid it. This old guy says, why, Fannie Williams, why, God, why the black man? Ronald Rowe, same thing. Why, God, why? If only they would have looked left. This old guy, Willis, sheesh. Yeah, she's having a hard time over there. I think that young thug case is also going off the rails. NY Renal says the new Secret Service director is a biased replacement. He's terrible. He even stated his best friend was the sniper. Crooks or the counter sniper? Somebody should have asked him that. You mean Thomas Crooks was your best friend or what? He can't truthfully evaluate this situation. The media has given Biden a huge pass on this event. No one was fired. It shows the media is covering for the Democrats. Yeah, the whole apparatus. Even a lot of, it's bad. We've moved on from it, from an assassination attempt. No repercussions at all. Had a couple hearings. That's the end of it. V is never silent says, Bible, another name connect. This name thing is so bizarre. So bizarre. Flagpole guy is here, says, I'll offer my boom truck to Trump for security services, guaranteed to identify and eliminate all threats. Look how high that thing gets, man. That's a serious purview. You could put here's my question though. Is it sloped at all? Probably not, right? It's probably nice and level. Good. Put a bunch of Secret Service agents up there. That'd be great for him. Hey, DJ. What's up, DJ? Says that video was taken by one of the men that got injured at the rally. One of the videos was. I don't know if it was that exact one that we played today, but one of the videos was. I think it was the one we played yesterday. Goofy for Jesus says, have they said why the gun was so far away from the body? No, I don't think I've heard an explanation for that. And I have seen photos that look like that the gun is a little bit far away. But no, I haven't seen an explanation for that or a question on that. ELZ says, this is so different from the JFK assassination. In '63, only a couple of 8mm films clips and one recording from an open mic on a police vehicle were ever available to the public. And it took months or years before it was released. Contrast that to all the information we have at our fingertips within a matter of hours. Yeah, I agree with that, ELZ. We've seen a lot of different angles, but I'm actually a little bit surprised that we're not seeing a lot more. Like, I would expect to see thousands of different angles of this. Like HD, multiple HD. I can't. It feels like maybe a bunch of it's been gobbled up and we have not seen it all. We've seen a lot, but it feels like there's maybe we just played the one yesterday. That video came out after it was seized by the FBI. What else have they seized? What else have they not released yet? Who knows? Michael Waller. What's up, Michael? Thanks for this one, man. Thanks. Very nice dono. No comment, but very supportive. Very thankful for you, and I appreciate that one coming in. We got Rick D's here. What's up, Rick D? 5 membos. Dirk from Texas came in with a new membo. Don't mind me. Terry Fields, Judge Maddie, and Robert Catlett, don't mind me, gifted a membo as he's modding the fort down for us. Hey, what's up? Elf is here. Thank you, Elf, for bringing in 5 new membos. And Shaw got one. Sanis 180, Ken Phillip, Captain Flat-tastic, another membo, and Adam M, all gifted membos, courtesy of ELF, bringing them in, new membos. Hey, Patty Grimes, membo for 2 months. First month's the hardest, gets easier from there. Glad you made it to 2. Says, I identify as you, Robert. I don't know if you want to do that. It's a lot of work, having to deal with myself. You sure? Your pronouns would be a pain in my ass. You know, it's kind of how I am. All right. What's up? Patriot Rob says, let me get this straight. Police involved shootings are the only jobs where you get put on desk pending the investigation. Why not the Secret Service? Well, I don't know. I think that they want to maybe protect Trump again. Well, we'll just protect him again. We'll try it again. We'll just try it again. Here's one from Patriot Rob. This one from Bobsco. Gifted 1 membo from Jay Liebgott. 1 membo from Bobsco, bringing in Jay Liebgott. And here from First Amendment, Roberto Missed First says, twice a day's Robert Gouveia, I'm worried. Roberto, Mrs. First says, because this is from First Amendment, twice a day's Robert Gouveia, I'm worried. It is a lot. As I said in that last comment, yeah, it's a lot. It's a lot of Rob. I have to live with myself. It's 24/7 for me. It's a lot. Tell me about it. Rick Donner, do you think Judge Juan Mercan bails or gets really dumb? I don't know what he's going to do. He's stuck. I think he has to dismiss the verdict. He's going to try to find a way to separate the spaghetti from the sauce. It's going to be hard to do that, but he's going to try to separate them out. I'm not sure he's going to be able to do that. So he's going to, order a new trial. Like, definitely he's not going to sentence him to jail. Gets off the case. I don't think he gets off the case. Maybe he postpones it. Or the Court of Appeals comes in and does something. I don't know, but he's stuck. This one came in from Seebeck. What do you think, the MIB or the Matrix? Yeah, I don't know. He looks more like MIB. I think that's the neuralizer right there in his front pocket. This one came in from First Amendment. Correction, twice a day, Robert Gouveia. Oh, twice a day, Robert Gouveia. All right, it's a little rhyme there. Nice alliteration, Mrs. First Amendment. Mr. Magic Man says, seems like the one thing that was definitely included in the Secret Service plan was the plausible deniability angle. Yeah, we just made a mistake, a bunch of them, and we're really sorry for it. We're going to do better next time, and that's it. We have a dead person, almost a dead president. So, not good. What's up? Von Miller's Crossing says, for all you intensive purposes. Yes, that's true. And you porpoises, too. Anybody who's intensive with their purposes are welcome here. One old guy's opinion says, Alvin the Chipmunk Bragg and the New York injustice system is effed up from the floor up. Ain't that the truth, says Left Right. Yeah, it's pretty simple. It's true. It's bad in New York. And what's so weird about New York is like they love it. They're like, this is how we govern ourselves. This is our version of justice as New York citizens. Okay. One old guy's opinion says, correction, Alvin the Chunky Chipmunk Bragg. Yeah, he kind of reminds me of the Marshmallow Man, too. Alvin the Marshmallow Man. Kind of walking around New York, like wrecking buildings. Hey, what's up? Steve Bear's dad. You're kidding. Membo for 4 months says, I'm a 3-month. I think you're a 4-month, but if you want to identify as a 3-month, Steve Bear's dad will accept it. Thanks for being a membo for 3 months. Libby T says, thank you, Libby. Thank you back. Thanks for supporting us. Thanks for being a membo, Libby T. And thank you back. Nice pair and a bow. We got Spuds here. 17 months as a membo. That's almost 2 full babies. Says Kamala actually passed the word salad bar exam. The word salad bar exam, which is very easy to do, especially once you've had a couple tequilas like she does. Seebeck says 10-4, I do security at my church. Oh, is that you? Is that you? Okay, MIB. Is that you? You look good, man. It's a sharp look. What do you think? MIB or Matrix? MIB, that's the neuralizer, obviously, right there. Is that a neuralizer? It's the neuralizer. I know. Be careful with him, man. He'll make you forget everything. Is that you? You look good, dude. You look good. It's a nice outfit. You do great. 10-4, I do security in my church. Love it. That's great. Well, don't flash our memory here, okay? All right? We want our memories here. Although it's been, you know, it could be a good solution. It's been a couple of years. Can you flash away all the Biden horror? We wake up, it's a better world. All right, here's one. One old guy's opinions says Juan Mercan can't unscramble the eggs in his courtroom. No, you can't. Once you broke those eggs, baby, that's all you got. So let's see what's happening with our friends over on X before we wrap it up and go on over to Locals to hang out and debrief over there for a little bit. Shout out to our friends on X. We've got Danny McWilliams says, looking more and more like a government hit from Danny McWilliams. It's certainly looking like it. Hey, what's up, El? We got El says, great analysis. Angie's here saying, good evening. What's up, Brandy? Saying hello from Michigan. We got Silicon Valley Reject over there with a bunch of images about Alvin Bragg and some other spicy stuff. So you want to follow us? That's where you can do it, my friends. At Rob Govea, ESQ on the X platform. But now we are going on over to watchingthewatchers.locals.com. It's our members only community on Locals. We'd love to have you join us over there and come hang out. But if not, we are going to be back here tomorrow. And so before we wrap, I want to thank you once again for subscribing to our channel. If you know somebody who might enjoy our content, we'd love to have them join us over here on the channel. Thanks for sending them a link. Thanks for sending them a short form. Thanks for letting them know we go live here about this time every weekday. And we'll see you and them back here. But we will be back tomorrow if we don't see you over on Locals. Stephen Mosher says, y'all being distracted into conspiracy theories. Y'all being distracted into conspiracy theories. And they usually are conspiracy theories. And then they're right, you know, though. That's kind of the thing about them. It's kind of one of those strange things that happens. But my friends, we are going to leave it there. We are going over to watchingthewatchers.locals.com. We'd love to see you there. But if not, we are going to be back here tomorrow to get into it again. And as you know, in order to do that, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.